number 176, in the matter of Leo. Good afternoon, Counsel.
Good afternoon, Your Honor. My name's John Clennon. I represent the appellant Donald Leo. I'd ask for 2 minutes for rebuttal. Today, we have two important concerns before the court. One is the construction of a rule that permits the sale of legal practices. It's a case of first instance in this court. It is only the second highest court of the United States to reach this issue. The other court was the Supreme Court of Minnesota some years ago.
Also, sorry to interrupt you, but is that really the issue here? I mean, is the issue really how do you sell your practice when you're about to be disbarred? Or is it under what facts and circumstances did your client do that?
Right.
Right? And how was the money from that dispersed? And again, I don't think you can disassociate that from what he was originally found to have done.
Well, okay, well, what he found to have done was commingling, not larceny. No
Right.
client lost any money.
Right. Well, it was a balance issue. But if we go to what he did then after the sale, he taps into the escrow fund, he's paying off his people in the office with funds that belong to his clients.
After the sale, or,
No, before.
okay.
Then he has this sale, and I have a lot of trouble understanding what money he's getting from this sale. Because in the first hearing, he tells a story that he's getting about $500,000 in disbursements, non-taxable disbursements, up to '07, at which point he gets $300,000 in something which he doesn't feel a need to have to actually characterize, but because he's his son, but some part of that may be the purchase price. Then there's an adjournment and an indication they're not going to recommend reinstatement. And then he comes back a year and a half or so later with a file of here's what the actual money was, which is, as I read it, although it's very difficult to understand, significantly different than what he testified to.
Well, what I'm telling you is that in the interim, if you read my brief, and remember what went on in this court and the appellate division, second department, the value of negligence cases shrunk. The soft tissue case was driven out of the
Counsel,
court.
it's not the value, it's what he actually received.
What he actually received is reflected in his tax returns.
When?
When?
The first
For
hearing or the second hearing?
The tax returns that were submitted to the board, and the board had no objection to his
At the
tax
first
return.
hearing or the second hearing?
I believe the tax returns had to be submitted, according to the appellate division's order, before the first hearing, yeah.
So he never amended his tax returns?
As far as I know, that there was no change in the tax returns. There's none developed in this record.
But it seems to me he's claiming in the first hearing that $500,000 of what he's paid are disbursements, which wouldn't be taxed.
Right, it's not
And then
taxed.
it turns out that's actually not accurate at the second hearing.
Might be not accurate, yeah. But I mean,
So they're
how much
actually
money did I
fees.
make last year? I can't tell you. I have to look at the tax returns. I would never
Right,
hazard a
but you would think
guess.
you would look at your tax returns before you go into the hearing. So at the second hearing, he goes in and he says, no, those were fees. Fees are taxable. So at the first hearing, he just hadn't looked at his tax returns and he actually was paying tax on that?
I don't know whether he was testifying. The record does not reflect that he asked for permission to look at his tax returns before he testified. And I think you're going to an issue, really, that's a non-issue. It's not the reason he was turned down for admission. He was turned down for admission because the full committee and the subcommittee said that the sale of practice regulation was not adhered to, that he should have notified past clients who had left him and went either to his son or somebody else. And what we're saying...
Well,
Okay.
that's one of two issues. That is one of the issues. It has to do with the notification, but it seems to me that what certainly the subcommittee felt was most troubling, because it was the reason for them to come back, was the issue of how the money from the sale was characterized.
Well, again, the existing, on the tax returns are not part of this record. I don't know what the tax returns are.
We're not talking about the tax return. I mean, he eventually goes back to court
Right, and
to get permission to do what he should have done, or did what he should have done in the first place, before.
Well,
15
again,
months.
that's what your court is going to decide, whether you can read a referral regulation into a sale of practice rule that's in the Code of Professional Responsibility. That's the issue that's before the court right now.
Okay, so your argument is that he never had to do that. He just.
Well, he did it because he was told to do it by the subcommittee, and that wasn't the rule, that the rule which governs the sale of practice does not put that limitation on it. There is no requirement, as there is in other types of...
But there are rules about what a suspended or disbarred or resigned attorney can do and can receive and not receive, and how they can do it
But you see that-
after they're no longer practicing law. And-
There's a difference
and so
between-
there's an overlap there, isn't there?
No, I don't think so. I think there's a difference between a referral. A referral is, here, take this case, I really can't do it. A sale of an entire practice is you're selling the goodwill of a firm, the willingness of people to come back and do business
So
there.
you could sell
the
your
telephone
firm the
number.
day before you're disbarred. I sell my firm to my son. I have an arrangement that I'm going to receive fees for work done on cases that as of the date I sold to my son. And then 2 days later, he starts dispersing money to me off of settlements, but I don't have to report that as a disbarred attorney to any of the court and get approval for those fees.
It's compensation for the sale of practice. That's the way this agreement is structured.
I think one of the things that certainly troubles me is how cute this all was. I mean, he's facing disbarment, and without telling anybody outside of what he knew was going to happen, all these clients end up with different lawyers. His son ends up, with the practice. He's getting monies out of it. It all seemed lawful, He didn't take his medicine for being disbarred. I mean, it's not a 7-year suspension, as some
Okay.
people have said.
Do you think that what you're trying to do, again, way back when, if I had been allowed to give my presentation, I would have told you, when I was very young, I picked up the old Long Island Star. There was a picture of the Queens and Nassau Bar Association in a joint meeting celebrating their anniversary. And it was a bunch of white men sitting in bleachers in a park. To replay that whole scene, we would have to rent out Citi Field. There wouldn't be all white. They wouldn't all be veterans of the Second World War. They wouldn't be all from Judeo-Christian denominations. There would be women. It wouldn't be all men. Today, we have such a diverse group. We have to look at what the written word says. What does Judge Holmes, who was kind of an adversary of Judge Peckham, whose picture is out there, what does he say about a diverse population? You have to rely on the written word, because we write down laws because populations are diverse.
Why was there an attachment to the sale agreement laying out percentages of each of the cases?
Because that's the way his attorney structured it. If I had been the attorney, I wouldn't have done it because I'm too lazy.
But on a pure sale, and you're paying the X amount of money as a purchase price, why do you need the percentages? It doesn't make any sense.
Because that's the way they structured how much the firm was worth. And as far as being cute, well, you're not required to advise everybody you know that you're thinking of resigning or that you have charges that might be pending. There never was charges launched here.
But had he sent his resignation letter in
That's
when he
correct.
sent-
But you're not
So he
required
wasn't
to
thinking
notify...
about it. He had
the-
sent a resignation letter in.
But the rule doesn't say, I shall notify my client when I send out the letter. It says, when the court accepts it. you must
But
notify the
going to
client.
Judge Pigott's point about how this looks, he sends a letter out saying, "I'm relocating." It doesn't say I'm resigning. It says I'm relocating to Tennessee or relocating.
And he did.
And he did, but he had also resigned. He had sent his letter of resignation in at that point.
Not in
and
effect, he was
facing
still an
disbarment.
attorney till July.
And he then refers to it as us, and if you want to stay with our team.
I think he said the new
And doesn't that go to
team.
Judge Pigott's point?
I think he said the new team.
Our new team.
Well, you know, again, I didn't draft the letter, but I can tell you that the letter conform does not violate the rule because he hadn't been disbarred yet. And again, how you feel, and again, when there were those white men, veterans of the First and Second World War, sitting on the bench, they could run bar discipline by winks and nods.
Thank you, Mr. Excuse me. Thank you, counsel.
Okay, thank you.
Mr. Clennon. Counsel?
Please, the court. My name is Robert Cabell for the Grievance Committee for the 10th Judicial District. As was alluded to earlier, one of the primary vexing problems in this rather cute scheme was keeping the clients in the dark. The whole thrust of this was to, one, keep an intact law firm until he came back from reinstatement, two, during his enforced absence as a disbarred lawyer, collect income without court oversight or client consent, and three, keep the clients in the dark so that the scheme could...
But would you at least agree that the language of the rules is a little bit ambiguous about, so what does a person do before they are, I mean, is there anything that says that a person has to send out a letter saying, I may be resigning, or I may be disbarred, or I may be suspended, and, and I'm going to Tennessee, and I'm selling my practice? Is there anything that says they have to do that?
Not in the literal language of the rule, but this matter is of a whole. What happened here was the
Well, I
sale of
understand,
the
but I guess I'm trying to parse out the two. I see two aspects to this. One is the letter, and I think that's a little fuzzier than what the rules are about collecting fees.
Well, the fuzziness can probably be dispelled if you consider it in this light. At the time that letter went out, aside from its failings in properly advising the clients of the realities of the facts on the ground at that time, he was clearly under the cloud of a disciplinary investigation. He had clearly already resigned. He had clearly made the determination that he was going
See,
to be
that's the problem.
disbarred.
That's really the problem, and the way I understand Judge Stein's question is, in the first part of the two-part analysis that the committee came out with and was accepted by the appellate division, the first part is the violation of that rule, 66910 or whatever it is. And there's a distinction that I understand the petitioner to be arguing between the submission of a letter and the acceptance of a letter. And my experience on the appellate division was always that we had to accept your resignation. There was no guarantee that we were going to accept your resignation. So hypothetical here is, what if you hadn't accepted his resignation? Well, then you would have went to further hearings, the court would have, and it would have went on for a while. During that time period, it seems that he could go forward and attempt to deal with whatever was legally possible or ethically possible with what remained of his practice. And you're asking us to establish a rule that the submission of a letter of resignation is tantamount to the acceptance of a letter of resignation in terms of its effect. And that doesn't seem to make sense to me.
I wouldn't accept that characterization. of
Okay,
what we're
you tell me
proposing.
why not then.
Because, first of all, I don't believe that a resigner attorney in this appellate's position.
I'm sorry, you don't believe what?
I don't believe that a resigner attorney, that was this appellate's position at the time of the purported sale, could invoke at that time DR 2-111. That is a very limited rule. It only provides for three categories of persons who can sell a law practice. He's not one of those categories.
Well, let's just stay with the question first of, when is he off? When does it happen? When he submits the letter or when the appellate division accepts it?
When
When he's resigned. That's right.
disbarment occurs when the appellate division issues the order accepting.
All right, so until that time, still an attorney, right?
Correct.
All right, go ahead.
He's not an attorney in good standing, however.
Well, that's, okay.
And
That's
that's our
that's a
interpretation of
much
the
more
rule.
fungible question. I tend to think you're right, but leaving that aside, go forward with the meat of it, which is his particular actions in this case.
Well, in the particular actions in this case, being on notice that there was a possibility he was on the brink of disbarment, it was certainly in the contemplation of the appellant and his son, because it's actually mentioned in the agreement that he has admitted it, and it was expected that he was going to be disbarred. And under those circumstances, perhaps he didn't have to send out a letter stating in prospective fashion to his clients, I may be disbarred. But what happened here was he placed himself through this guise of a sales agreement of being in the position of assuming or claiming that he no longer had any clients to advise of the disbarment.
Well, isn't the purpose of the notification so that the clients are protected, so that they know that they have to get someone else to protect and represent their rights because this person is no longer available? I mean, that's a major purpose of this,
That's
right?
exactly the point.
And that
yes.
happened here, didn't it?
No, it did not happen. These clients did not know that their attorney, up until this point in time, was going to be disbarred.
What difference did it make to them and their rights at that time?
It would
They
seem-
knew that he was no longer going to be available to represent them, and they needed to get somebody else to do so, and they got that notice, and they were able to go ahead and do that.
It would seem to be beyond dispute that those clients would have liked to know that that lawyer was disbarred as a factor to considering whether they're going to continue with this law firm.
Well, I don't know about that.
Since
And
the
did it-
purpose of the
When he
rule,
was disbarred, did that become public? Was that public knowledge then? Public?
it's a public,
Public
it's a
information?
public order, yes.
Okay.
But the public in the general world probably wouldn't know about it. And that's precisely one of the reasons why 691.10 requires notification to the clients and to other counsel. Because if we are
But I
talking
don't
about
understand
the...
what it is that they're supposed to have said, that he was supposed to have said at the time he sent his between the time he sent his resignation letter and the time that it was accepted. What should he have told his clients?
I think that one of two possibilities here could have been followed by this appellant. One, he could have just been forthright and said,
He could have been.
I'm in trouble, this is what I've done, I may be disbarred, and I'm leaving.
But isn't that a major reason why an attorney decides to resign rather than face the charges so that they don't have to project that to the world?
No, because it becomes projected to the world once the disbarment order is accepted. The
So
facts and
why would
circumstances
an
are out.
attorney then resign rather than let them go ahead and try to prove the charges? And maybe he'd only be suspended for a couple of years.
Well, that's a strategic decision that that attorney has to make. He's
No,
under a
but
disciplinary
Why
investigation.
would he do that? If he's essentially agreeing to be disbarred, why would he do that?
Some attorneys don't want to go through the trouble of a
But
hearing.
essentially,
It's
it's
a
You don't
very-
see any
it's to control
policy,
the
good-
timing, isn't it?
Sometimes it is, yes.
Seems to be the primary reason,
That's correct.
is to control the timing of it. And that's what was done here. They wanted
And
to control
sometimes
the
it's a
timing.
matter of not having money to pay counsel to do a hearing.
Sure,
There's a lot
there's
of
all-
other reasons.
you're
but-
Don't we
Absolutely
want to
right, but-
encourage that?
I'm sorry?
Don't we want to encourage that as a policy matter?
Encourage,
Isn't that good so that the resources of the disciplinary committees and the courts aren't needlessly used? If an attorney is willing to do that and save some face?
well,
or-
I don't, okay. Certainly, it would be, from an efficiency standpoint, it would be fine, but I don't know that as the price for efficiency, you want to accept an interpretation of a rule that leads to a deception to the clients.
Well, let's look at that deception for a minute. If this attorney, who apparently is pretty good, I mean, there's an awful lot of clients there, if he's in a big firm, and by big, let's say 30 lawyers or more, his ultimate suspension or disbarment will have an impact, but the firm will go on. If, on the other hand, you're a sole practitioner and you want to protect your son, as, you know, seemed to be a possibility here, is that a bad thing to say, you know, I'm giving my practice to my son, and then when they find out 6 months later that he's moved to Tennessee and/or he's disbarred?
Certainly, it's a bad thing for the son if they find out that the father was disbarred.
Why?
But the purpose
Why?
of...
Why? Why is it a bad thing for the son if you find out your father, I mean, it's a sad
Well,
thing,
the
but...
clients may leave the firm if they actually knew that the father had been disbarred, and the son would be left without a firm.
I mean, if you're, okay.
But counsel, another issue I see with this letter is, he wasn't disbarred at the time. But wouldn't it have been accurate, and your obligation to not misrepresent anything, to say, I have submitted my resignation, not I'm relocating, and our team and our people and our firm, giving the impression that while I may be off in another state for a while, you know, I'm not ending my practice or intending to end my practice in any way. That, to me, is troubling about this letter, not in the sense that I had to notify people I was under disciplinary proceedings or notify that I was going to be disbarred for all intents and purposes, but at that point, he had submitted his resignation, right?
Correct.
And the letter just says, I'm relocating.
I agree with you. The letter is misleading in the extreme, putting aside the question of whether he had any obligation to advise ahead of time that he was facing possible disbarment. Putting that issue aside, the letter in and of itself is misleading. It's misleading of the circumstances, it's misleading of his intent, and it's misleading of the clients whose interests are supposedly being protected by the rule, who ought to be able to decide for themselves. Do we want to continue with this firm?
You know, you're making, I apologize, but your light is on, and one of the arguments, as I understand it from the petitioner here, is that the appellate division did not explain anything. They just said, you know, and you're making arguments, some of, you know, I should say some, but articulate arguments on why, but the appellate division didn't say that.
Yeah, well, this court's decision in the Citrin case, I think, is dispositive of that issue. In that case, this court determined that as long as the record as a whole provides notice to a denied applicant for reinstatement, or in that case, reinstatement,
But one of the
due
things
process is satisfied.
One of the things I was thinking about when you were talking about that is there was no charge. There was no charge. You didn't charge Mr. Leo with misleading his clients after his resignation and before his disbarment.
Well, this matter, that aspect of things didn't come forward until the reinstatement application.
Right. So you didn't charge him on it, so that can't possibly be the reason why he was disbarred. And if it's the reason why he's not being reinstated, shouldn't there be something in the record that...
Well, there is. The full committee's letter stated two reasons. One, the letter to the clients upon the sale of the law firm violated the court's rules, and the second reason was violating the court's rules relating to the payments of the fees and disbursements
Percentages.
without court approval,
Okay.
and without client consent as well, because the rule also requires notice to the clients that a disbarred lawyer is going to be a payee in quantum merit.
Thank you, sir.
Thank you.
But could I just ask one?
Yes, one more question.
Your adversary mentioned that there was no obligation to go to court because that was part of the sale. Could you comment on that? There's no interplay between the sale and the requirement to get court approval?
I don't think that by private sales agreement you can abrogate a court rule that requires that a disbarred lawyer obtain court approval for pre-disbarment quantum merit legal services or disbursements.
Thank you, sir. Counsel?
What I think we're trying to do is go back to the way it was before, when you couldn't sell a practice. That's what I think we're trying to do over here. We're trying to read into a regulation different requirements that aren't there. We're trying to...
Your client went and got the orders, right?
That's right.
All right. So,
I was there when he got most of them.
All right. So he must have felt like he should go get them. And he got
Actually went there because the subcommittee told them to. And looking at what happened here is that not one Supreme Court judge, we went before 6 of them, not one had the least objection to it.
We didn't see the papers. I was curious about, you know, the application, you know, for the orders and to whom notice went. And
At that time, I represented Donald Leo Jr.
and the orders itself.
They went to all his former clients. No one showed up in court to oppose the procedures. No one contacted either me or Mr. Leo, who's now my client, to find out what the story was about. No one contacted Donald Leo Jr., who was my client at the time. But what I'm
They're all
telling...
fees that are coming out of the percentage that went to the law firm, right? So the law firm gets 33% on a case. These fees are how much does your client get and how much does your former client get, I guess, in that distribution, right? So why would a client object to that?
Again, the client has the right to.
Right, but what I think Judge
I mean,
Pittman
I
is
have
saying,
had-
you
I-
haven't seen the papers, so you file these things which now say, no, they're not, some of this isn't disbursements, and this part isn't the sales price, but they're actually tied to the cases that you had in the appendix to the sales agreement, and the court says, okay, that's what you did, right?
Right. We attached the sales agreement and showed that that was the agreement that was made. That's correct. We also
Do you
attached...
care to address the second issue regarding the appellate division's failure to detail the reasons in its...
Well, you see, what we have here, and different from the days when you had the men sitting on the park bench and could run the bar by winks and nods, what you have here today is a disparate group. We have to run it closer to the book than ever before because there is no common moral focus anymore. We have people saying today that the Ten Commandments shouldn't be out in the parks. So something so fundamental as that, there are disputes over. What is the common moral focus is the black letter of the law, and it has to be objectively applied. Why shouldn't the appellate division explain it? Well, every other profession that you have, in order to get a disciplinary proceeding through, it must be
So
explained.
you're saying we should overrule Citron?
Well, I think Citron, by subsequent cases, was being cut down on. I believe Matter Anonymous said that, if they considered extraneous matters not in hearings before or not generally open to the public, they had to
But you're not,
provided-
you're not arguing that your client didn't know what the charges were, certainly
Well-
the committee said what they were based on, and the appellate division, I think we can,
rubber stamp them.
or agreed with them.
We
They
don't-
didn't feel it was necessary to add anything.
Well, they didn't say for the reasons stated. There's ways your court, ways that court, sometimes they agree with a Supreme Court judge, and they say for the reasons stated by Judge so-and-so.
Thank you, counsel.
Take care. Bye-bye.